Justice Kavanaugh?
See, I appreciate your having alternative arguments and a party having alternative arguments. I think that's helpful because you don't know where the 9 of us are going to go. But then it's important to for me to keep clear on what the alternatives are. Your first one's the contract, no exceptions. Okay. The lower courts have not gone that way, have rejected it. Assume
Correct.
I'm not going that way.
Sure.
Okay? Just me.
Sure.
Okay? So first alternative out for me. On the second alternative, I think you raise a good point. What source of law are we doing? But all the lower courts have been doing it, right? All the courts of appeals. And I could be federal common law, could be supervisory power, but it's there. And I think I'm just taking that as a given.
Yeah, courts have done it. The way this has arisen is courts, in the early 2000s, late 90s, often confronted with this would say, yes, these are okay, but of course we would never enforce it in XYZ circumstances without really explaining why. But yes, they have said that. But they have said that.
At this point, I take your technical point, and maybe it's more than technical. Where does that come from? But it's everywhere in the courts of appeals. My old court, every court, right? And it might be interpreting the federal criminal rule, it might be supervisory power, it might be federal common law, it might be going to what an appeal is in the statute, to Justice Gorsuch's point. But it's there. Then it's just what are the exceptions, right? Okay.
Yes.
So if we're on that, it's just what are the exceptions and whether to identify a general miscarriage of justice or to list 3 or 4 and then to say they're not exclusive, correct?
Correct.
Okay.
Correct.
And there's a pretty good consensus of exceptions in most of the courts of appeals.
Correct. Correct. And the ones that we've articulated, I think,
in other words, I think this is not so hard in the sense that there's a kind of defined list. What happened here is the list is shorter than what most of the courts of appeals have. Correct?
If this court is going down that road, I think saying there's still a defined list, there's just, 2 more bullets on the list.
Exactly.
We can live with that
exactly.
as long as the last bullet isn't catch-all, know it when you see it, if it's sufficiently egregious, because that is a real problem for us. If the bullets are if you just say the Fifth Circuit has 1 too few bullets, 2 too few bullets, that makes sense. But again, we don't think there are any bullets that could capture petitioner's argument.
Well, the D.C. Circuit, we did have a bullet that said results in a miscarriage of justice, and I don't remember the place falling apart.
So I do think that if this court were to announce a standard like that, we would see kind of a flood of that. Okay. And there has also at this point been kind of enough common law, I guess, built up around it that courts have denied those miscarriages enough that defendants may raise them less. But if this court were to announce that standard, we think defendants would raise them a lot. And again, I'm not suggesting courts would find miscarriages of justice constantly, the opposite, but that's the very problem. I mean, if we're looking for the needle in the haystack, but in every case we're being deprived the benefit of our bargain, that's the problem.
And the ultimate benefit is the resource. Right?
Correct. I mean, we enter into 45,000 plea agreements a year.
Ultimately, it's a judge-protective thing, too, because the judges are, I
Correct.
got all that. The amicus brief of the Association let's see, which one? The Association of Federal Defenders says if we are too strict on this, there are going to be fewer plea bargains, so the resource problem is actually going to be worse. Do you want to respond to that very quickly, because I'm using time?
I don't agree with that. I mean, the most common alternative to entering into a guilty plea pursuant to an agreement is not a trial. It's entering into a guilty plea without an agreement, where the United States gives no concessions and the defendant retains his right to appeal his sentence. That's, I think, kind of the most common alternative that we have now, and that's, I think, where things would get channeled. So I think we'll still have pleas, but those pleas will probably be less favorable to defendants because we're not giving the concessions.
Thank you.